everyone. So we have really attractive giveaways for you. Please give a shout out about the conclave sessions in the link provided in the chat box by tagging Aussizz Group and Aussizz Conclave 22 to win exciting offers. For more information, refer to the chat box. Welcome everyone. We are doing our biggest virtual event of the year, and that is 5-day event we have been doing. This is the fifth day, the last day, where we are covering more than 35 topics, and that has been delivered by register migration agents. We have more than 35 register migration agents working at Aussizz Group, and also we have more than 50 education qualified education consultants or counselors providing information on the various topics. So here we are. We have been doing this virtual event for some time now. Last year also we did it, and we made it completely virtual so that more people can attend. And even though if you are not available to attend face to face because you are situated overseas or in some other states, that's where you can attend the session. You can share it with your friends comparatively very easily, and that's why you have been doing this virtual event as such. Um, just moving on, about myself, I am Parth. I am a registered migration agent at Aussizz Group. Um, I am also director of Aussizz Group Hawthorne. I've been with Aussizz Group since 2014, and since then I have been providing advice to prospective migrants or students on studying courses or to migrants settling in Australia. Our contact details are mentioned over here. Also, we'll be sharing our contact details in the chat box. If you have any queries later on, if you'd like to discuss your personal scenario, just contact us on that numbers, and we will be providing you one free consultation because you have been attending this session. About Aussizz Group, um, about Aussizz Group, we are immigration and education consultants, putting our emphasis on client satisfaction. So we mainly look at clients' requirements and we provide them advice accordingly, looking at the best possible way and uh, the ways which can reduce the visa risk, helping with Australian permanent residency or citizenship options. We have more than 35 agents, as I said, and more than 50 qualified education counselors who can help you with um, doing enrollment in the courses, or if you'd like to change your course because you are not able to complete the course which you have enrolled in because you've found out some issues with the course or the university. So we can help you with that. If you have any queries, any concerns, or you need any assistance with any migration matters, it could be any Australian visa, we can help you with all of that visas. Um, Moving on, we have 17 offices currently in Australia, and we are opening two more offices soon, probably in a week, 2 weeks of time. So which will make altogether 19 offices just in Australia. Apart from that, we have offices in UAE, India, and New Zealand. In Australia, we have covered most of the states, and we have multiple offices in particular states as well. So the nearest state, wherever you are located, you can reach to our office, and we will be more than happy to help you with your queries. About the event, as I said, it's one of its kind of virtual event directly from Aussizz Group, where we try to cover insights about the programs, career and migration future pathways across most demanded occupations in Australia, or demanded occupation from students. So we try to cover most of the topics what we can in this 5 days session. We have some more topics coming on throughout the day, so the links for that will be shared in the chat box. Uh, you can join that session as well, or if you think you have any friends who are interested in joining that session, you can share them the link, and it would be great for them as well so that they can take benefit of it. Okay, now moving to our topic, we are going to discuss about the partner visas. So we are actually going to cover all of the partner visas. If you have any queries, leave your queries in the comment section, chat section, and at the end of the session, I'll try to cover all of your queries. If your query is not covered, just give us a call on the number provided in the chat section, and we'll be providing you a free consultation so that we can discuss, we can help you with your queries and show you the pathway how to apply for the visa. Okay. So who can apply for a partner visa? So that's the basic requirement. First, primary requirement is that you must have an Australian partner. Australian means if you have Australian permanent resident or Australian citizen or eligible New Zealand citizen partner, you may be able to apply for partner visa. So the basic requirement is you need a partner who is either Australian permanent resident, Australian citizen, or eligible New Zealand citizen. So what is eligible New Zealand citizen? So New Zealand citizens who arrived in Australia and were present in Australia on 26th of February 2001 on SCV special category visa, and they stayed in Australia for at least 1 year out of 2 years at that time, are considered as eligible New Zealand citizens. People or New Zealand citizens who came after that date are just holding a triple four special category visa, SCV visa, but they are not eligible sponsor or partner to apply for this partner visa. If you have any partner as such who is New Zealand citizen, you may probably first find out whether they can get permanent visa of Australia. Then you may be able to apply for a partner visa. Also, if you have New Zealand citizen partner who is in Australia on SCV's triple four visa, you may look at a 461 visa, which is New Zealand citizen relative visa. So you are, because relative of your partner who is a New Zealand citizen, you may be able to apply for a 461 visa, but that is not a permanent visa. That's just a temporary visa, but you generally get most of the benefits, which is like studying full time, working full time. Most of the benefits you get while you're on 461. However, you cannot apply for Australian citizenship. So, if you have a partner who is New Zealand citizen, you may first see if there is any option to apply for permanent residency. Department provided one pathway for New Zealand citizens under 189 New Zealand stream. So, if your partner qualify for that category, they may be able to apply for that visa, and you can be included in that application, so you can get permanent residency. That could be one of the option. But anyway, so for this partner visa application, simply these are the three options to qualify for the visa. Now, if you would like to apply for partner visa onshore, that is in Australia, you are looking at the category 820 visa, which is leading to 801 visa. So the partner visa are two-stage process. Initially, you submit application for 820, and 2 years after, you can possibly qualify for 801. However, the application, when you make 820 application, department consider that you are making 820 and 801 the permanent partner visa application together, so they will process your application together only. If they can grant you 801 visa directly, they will grant 801 directly along with your 820 visa. If they cannot grant you 801 visa, we'll talk about the requirements later on, then they will grant you initially 820 visa, and the date on which you applied for 820 visa, from that date 2 years after, you can apply for 801 visa. So what is important to note is that the 2 years of time starts from the date of 820 visa application, not from the date of the grant. So it doesn't matter 820 takes 6 months of time, 1 year, 1.5 year, whatever it takes. Simply you will be able to apply for permanent visa 801 after 2 years from the lodgement of 820 visa application. So that's how you apply for onshore partner visa and how you can get permanent residency. The good thing with 820 visa application is that if you are able to apply visa in Australia, you get a bridging visa, ultimate visa, to stay in Australia legally until your 820 application get processed. If 820 visa get granted, you already have 820 visa. If your 820 application get refused, You see the reason for the refusal and see if you can win the case. You can challenge the decision at AAT, at Administrative Appeal Tribunal, within the specific time frame, which is 21 days. And then your bridging visa will continue as you have applied to AAT and you are waiting for the outcome. So you get a bridging visa um, because you have applied for a valid application in Australia. So until you get the outcome, department grant you a ultimate the visa to stay in Australia legally, which is a bridging visa A. If during the processing you decide to travel overseas because of whatever reason, you will have to first get bridging visa B before you travel, and then you can travel, you can come back because you have a valid visa to travel. So bridging visa A, when you apply for partner visa, will be granted automatically. Automatically means once you submit the application, you get the bridging visa B, bridging visa A at the same time. Now once you apply for that 820 visa application, 820, when you're made bridging visa, when it's granted, it generally gets you all the rights, that is again study rights, work rights. You can also apply for Medicare. So even if it takes 6 months, a year of time, doesn't matter. What is important to note is that when you apply for partner visa, whatever the visa you are holding at that time, whatever the substantive visa, the main visa, for example, you are on a visitor visa or you are on a student visa or whatever the visa could be, you have to meet that visa conditions until you are holding that visa, because bridging visa will only come in effect once your main visa expires. So if you are holding a student visa for next 6 months, even though you applied for 820 visa today, bridging visa granted today, you have to meet your student visa condition. If it has a requirement that you have to keep studying, you have to work just part time, for example, you have to keep doing that until next 6 months. Once that visa expires, you will come on a bridging visa A, and then you can start working full time. Whatever the rights you have, you can do that. So that's how the process works. And once your 820 is granted, you work again, you can continue working. Once you qualify for 801, you apply for it, and then you get the permanent visa. So it's a two-stage processing. And until 801 visa is not granted, department would like to see that your relationship is genuine, continuing. Anytime in between, if your relationship break down, you will not be able to qualify for 801 unless there are some specific circumstances which we'll discuss in future and like in the next slide. Okay, so in order to qualify, there are three options. Option one is, because you are saying that I have a qualify, I have a partner who is also a permanent resident or citizen or a eligible New Zealand citizen. Now, in order to prove that whether that is your partner or not, for that, because citizenship or permanent residency, you can just provide with their visa copy. But then you have to prove also that you have a genuine relationship with your partner. How you prove that your relationship or what kind of relationships will be considered valid for this purpose? So for that, department has three options, mainly two options. Option one is de facto, you are in de facto relationship with your partner, or option three, which is option one and two are very similar. So option three is that you are in marital relationship with your partner. So either you are in marital relationship or you are in de facto relationship. Now for de facto relationship, standard options, standard option is that you are required to be in relationship with your partner for at least 12 months of time. If in case, if your relationship with your partner is not for 12 months, then the second option comes into picture, which is if you register your relationship with the state government, the respective state government, then you can use that certificate from the state government to qualify for the visa. That means there is no requirement that you have to wait necessarily for 12 months of time, then only you can qualify. So option one, if you are in relationship for 12 months or more, comparatively easier, you can apply. If you are not in relationship for 12 months, um, then you have to register your relationship with the state government. For example, Victoria, they have a website called BDM, birthdeathmarriage.vic.gov.au. Same way other states have the website like that. So you register your relationship there, then you can look at partner visa application. Another important thing is the relationship requirement of 12 months for option 1 needs to be met at the time of application. So that means if you think that partner visa application takes 6 months, 10 months of time, for example, so we are in relationship just for 6 months of time, you cannot make application now thinking after 6 months anyway I will complete 1 year of relationship. So the requirement is at the time of application. However, when you look at the option number 2, the relationship registration with the state government, it's not necessarily to be approved. So it's not necessarily that you have the certificate from the state when you apply for the partner visa. So if you apply for your partner visa, but during that you applied for certificate from the state government and you received it, you can submit it to the department can still consider. So it's not like the certificate must be received before you apply for the visa. Anyway, these are the three options. You have to qualify for any one of the option. If you are engaged, just probably like just probably dating, things like that is not considered for this purpose. You have to prove that you are in a genuine relationship for 12 months of time. There are some factors which you will have to prove, which we'll discuss in the next slides. Okay, so how you prove that you have a genuine and continuing relationship? So before that, for any relationship, if you would like to qualify, department look at certain factors. So if you are saying, for example, that you are in a de facto relationship, so then you have to prove that you and your partner are not married to each other. That's first thing, which is very common, basic thing to understand. If you are married, you are not considered to be in a de facto relationship, so you must not be married to each other. Secondly, you have to prove that you are committed to each other, so you are committed to share shared life exclusion to all others. That means you are in relationship just with the person to whom you would like to call as a partner for this purpose. Your relationship must be genuine and continuing. That means when you apply for the visa, at that time you are required to prove that your relationship is genuine and continuing, and during even your visa processing, you have to prove that your relationship is continuing. At any point of time, if your relationship break down, you do not qualify for the criteria for this partner visa. You are required to live together. If you are not living together, if you are living separately, you are required to prove that that separation is just temporarily basis, because department generally considered married applicants and de facto applicants the same way. They would like to treat them equally, so they expect that if there are people who are married, they generally live together, they have commitment to share life with each other, exclusion to all other people. So they would like to expect the same in de facto partners, and that's why they says that if you are not living together, you do not generally qualify unless that separation is just temporarily. So that means, just an example, this is just an example, it's not like for sure they will accept this or they will not accept this. But if you are in a relationship with your partner and your partner has been sent to some other state just to do probably 2 months training or probably 2 months of work because of some contract, or they are just starting a new company and they would like to set up things, and that's where he is going there, you can still prove to the department that that 2 months of visit is just a temporary visit which came in between for the work, and he is going to come back or she is going to come back after that 2 months of time. And anyway, before that also we were living together, and after he come back also we will be living together. So you'll have to justify, you'll have to prove to the department that that separation is just a temporarily, because department does not know that you are in separation is it just a temporarily or you are just permanently separated. If you cannot justify to the department can refuse your visa application. And you also have to prove that you are not related to related to each other by family. So that are the standard requirements. Now if you'd like to prove that your relationship is genuine and continuing, department look at four aspects. So the four aspects are social awareness of your relationship. So as I was telling, that department expect that people who are in marital relationship, other people know about their marriage. So same way they expect that if you are in a de facto relationship, you have to prove that socially people are aware of it. So this criteria what we are talking about applies to both marital relationships and de facto relationships. So no matter what, even if you are married, you still have to prove these things. It's not like if you are married you don't have to provide any other documents, just marriage certificate will suffice. Not like that. You still have to prove with your documents, supporting documents, that you are in a genuine relationship. So first aspect is social awareness of the relationship. Now for the social awareness, you have to prove that people are aware of your relationship. Now, how you prove that? So there are some ways. Again, it's not just limited list as such. You can provide as many documents as you can to prove that. But just an example, I will tell you that how you can possibly provide that. So, for example, you have traveled together with your friends, family member. You can provide photographs. You can provide tickets of traveling together, or you have been to some tourist places. You provide photographs, bookings, things like that to prove that you have been traveling together. Other people know about your relationship that way, because in the photographs you have there are other people in the photograph. So based on that, probably they can find out. You can provide declaration from that people saying that yes, they know that they are like you are in a genuine relationship. They know you for some time, and they know that you are in genuine and continuing relationship. So you can provide documents from your friends. You can provide documents, like in word file. You can provide photographs, and below that photograph you can provide description of that photographs, that we have been to this place with our friends, family members, things like that. Other than that, if you have been for any other activities, this is just like tourist places you have been. Same way, if you have been to some sporting activities or any cultural activities, any other social gatherings, for example, you have been to, so you will have photographs for that. So you can provide documents like that. You got some invitation, you can provide that. So invitation you can provide from your friends, family members who have invited you for their marriage, or for any other celebration, birthday celebration of their children, housewarming party, things like that. And you have your name on it. You can provide documents like that. You can provide some documents from other friends, as I said, a declaration from them, who will say that yes, we know, or how come we know each other, how often we meet each other, why do we think that they are in a genuine relationship, things like that. So you can provide declarations from them. And apart from that, you can also provide, in case if you have social media accounts where you have posted your photographs and people commented there, you can provide that screenshots to prove that yes, people are aware of your relationship. So things like that. So that's the first aspect. The second aspect is commitment. Commitment means you are saying that you are committed for a long term relationship with each other. So generally speaking, it's not necessarily that you are saying that what if I get divorced probably after 10-20 years, which no one know, for example. But department expect that you are saying that you are in a long term relationship. At least you have that commitment for now to share life with each other, for whatever coming years. Now, in order to prove that, you can provide details about, you can provide a relationship statement from applicant side, I mean, and then the sponsor side, explaining that how you know each other, how your relationship grew, and why do you think that, and what kind of plans you have in future. For example, you started investing together so that you can buy a house, or you are jointly investing somewhere for some betterment in future, things like that. You can provide that kind of documents. If you have some wills, for example in the bank you have provided your partner as a nominee, you can say that okay, yes, look, as you can see, we have a committed relationship, and that's where I have my partner listed as a nominee for my properties or for my accounts, whatever it is. So that's about the commitment. Generally you can't provide much things in that case, but then mainly it's about showing your commitment to each other through probably some documents. If you have about, probably if you have invested in a property which is probably you are going to build after 2 years of time even, but then you have both of your name on that, you can provide that. Then after, the third aspect you are looking at is living arrangements. So for living arrangements, you are that is generally you can say household arrangements. For household or living arrangements, you are saying that you are supporting each other in household duties. That is, you are living together, you are helping each other with whatever day to day work. It could be cleaning, it could be cooking, It could be anything else, buying things for your house, making joint decisions about that. So again, when you are providing the statement of relationship from your side, your partner side, you can explain how you are helping each other in day-to-day work. Um and then apart from that, if you are splitting bills, for example, or you are living together, so you will have some bills under you, your partner name, that could be water bill or lease agreement you will have, or any other kind of bills which you are making payments together, or it's not necessarily you are paying together, but then you have that bills which shows both of your name. If it is not both of your name, at least one person's name, and other person will have some other documents under their name which proves that you are living together, and then you are making payments accordingly, something like that. Apart from that, if you have if you have children and if you have a joint responsibility, so you can provide documents like that we are caring for our children jointly, things like that. So in short, household, whatever work you have, you are saying that we are sharing the duties, we are helping each other in a way. How you can prove that? Probably if you have some photographs, again you can provide documents like that. Or again, when you are providing declarations from your friends, family members, they can probably, if they have known you, they have found out that you have been helping each other with this kind of duties, they can also, when they are making statements, they can probably write down about that things. And then the last aspect is mutual commitment. The last one is financial commitment. So financial commitment means you are generally sharing your finance matters. That could be, again, as I said, the bills, or if you have some properties you are investing together, or you are, for example, you have your own house, you have spent money together with your savings, whatever it is, or any bills you are getting under your name, you are paying from joint account. If you have joint account, you can use joint account. It's not necessarily that you need joint account. If you have personal account but you have been depositing into each other's account, you can provide that transactions. Apart from that, if you are not living together, just for some time being temporarily, and you are supporting each other, for example, your partner is not working, and move to some other state, for example, just probably for 2 weeks of time, a month of time, and you have transferred money to them, you can provide that to prove that, okay, for her living expenses, for his living expenses, you have been supporting. In case if your partner is outside of Australia, you have transferred money, you can provide receipts like that. If you have gifted your partner anything, you can provide gift receipts, things like that. And then any other property related documents, or for example, you bought any um, any appliances or car, for example, any um, physical things, electronics things, big things, for example, you have been buying together, saying that we have shared to get this, things like that. So that are all financial matters. That's what you have to prove. Now, this is generally speaking for any relationship. These are the aspects department look at. These are called pillars, or the four aspects which are mandatory for you to qualify in this visa. Or for any other visa also, generally department look at that these four aspects generally any couple will be meeting, because if it is a genuine relationship, you should be generally supporting each other like that. Very important thing to note is that if you don't have that documents, I don't recommend at all that you try and go for that kind of documents to get it. Whatever you have, you provide that, but then it's about how you provide the documents that is very important. In the partner visa application, it's you who has to prove to the department that your relationship is genuine. um, Ultimately, because whenever you apply for any visa, department says we will be checking with your documentation whether it's genuine or not, but then ultimately it's your task to prove to the department that your relationship is genuine and continuing. So as part of this, we also advise our clients that suppose when we apply for partner visa, generally speaking, the partner visa processing time range anywhere between 2 months of time to probably even 2 years of time. Recently, last 2 years, department was giving lot of partner visas. They cleared lot of backlog, like much backlog in a way, because earlier the partner visa processing time was more than 1.5 years. But in last 2 years, they doubled the quota for partner visa in that financial years, and that's where they were granting partner visas very quickly. So we have seen some visa grants very quickly. That could be even in a month, 2 months of time, where the relationship is old. Otherwise, generally speaking, it can range anywhere between 2 months of time to 1.5 year of time. Now, because the quota has been again reduced to the normal quota what they were having a few years back, that's where slowly the processing time may increase, but approximately you are looking at 1 year of time. Now what we do is, what we advise the clients is that when you apply for partner visa, probably after 6 months, after 1 year, when department look at your application, they don't know whether your relationship is continuing, because there are two aspects. Your relationship is genuine and continuing. So genuine, probably you prove with some other documents when you applied for the visa, but whether it's continuing now or not, so for that department again will come back and say, we need more documents to prove that your relationship is still ongoing. So then you have to provide documents which may delay your application. So what we advise clients is that regularly, probably at the interval of 4 6 months of time, keep updating new documentation, so that when case officer, when department look at your application will be up to date. Anyway, focus more on these four aspects, because these are the main things what they look into. Apart from that, the other standard requirements are that you have to meet health and character requirement, which are basic requirements for most of the visas. This being permanent visa, department would like to make sure that you meet that character health requirements. In case if you're not able to meet health requirements, there might be some exemptions given by the department depending on the health issue, but officially these are the basic requirements. Character requirement also applies to partner who is Australian permanent resident or citizen. So department started asking for, they implemented new changes, asking for sponsor who is Australian permanent resident or citizen or eligible New Zealand citizen to prove that they don't have a character issue, because they have been seeing that in a lot of cases family violence was happening, and that's where department added extra requirement from sponsor side, that they also have to prove that they don't have any character issue, which can later on create problem to the main applicant, because ultimately department would like to make sure that people are not having any concerns about their health in future once their permanent residency has been granted, because they have been seeing a lot of issues has been happening in past. So they added extra layer of security or extra requirements that partners will have to provide police checks from every country where they have resided in last 10 years of time. So police check is required where the sponsor has lived in particular country for 12 months or more in last 10 years. So if, and that 12 months is in total, that means it's not like cumulatively, sorry, it's not like continuously you have resided in the country for 12 months, then only you have to provide police check. If you have spent 6 months of time in 2014 and 6 months of time in 2018, that is altogether 12 months, and that's where you will have to provide the police check from that country. So as long as 12 months has been spent in that country, particular country, in last 10 years, whatever countries your partner has resided or you as the applicant have resided, you have to provide the police check. So that's the character requirement. Okay, what happens after the grant of the provisional visa? So if it is 820, that is the provisional visa. 801 is the permanent partner visa. Now, once your provisional visa application 820 application is lodged, as I said, you get bridging visa, full-time study work rights visa. Once you get the visa, you have the same benefits pretty much, and you can travel to and from Australia as many times you want. Even during your bridging visa A, you can travel overseas, but not while holding bridging visa A. You will have to convert that bridging visa A into bridging visa B, and department generally does not raise much concerns. You just have to explain what is the reason for you to travel. Even if you have a simple reason of visiting your family or friends or your country, you can, no issue with that. It's just that you will have to take bridging visa B before you travel to your home country. You cannot just apply for bridging visa B and then go. You have to get your bridging visa B first, then only you can leave country. You can leave country on bridging visa A. The problem is you will not be able to come back. So as soon as you travel while on bridging visa A, your bridging visa will cease, because bridging visa A does not have travel rights. So if you have traveled You can go, but you cannot come back. So make sure that you take bridging visa B before you travel. Anyway, on the grant of the visa, you can also take up to 510 hours of free English language classes provided by Adult Migration Education Program. So that's for any permanent visa, government give you that access, so that you can prepare yourself for at least functional English, so you can settle in the country and you can possibly look for the employment in Australia. You can privately, if you'd like to take any education, you can, no problem with that. About English, if you don't want to take this, then after the permanent stage, which is 801 from 820 visa. So in this case, you will need to show that you are granted 820 visa. It's not necessarily that 820 visa must be granted. If 820 application, when you applied, because you are making together 820 and 801 application. So in case if your application 820 application takes 2 years of time until it's granted, so then department will straight away grant you 801 and 820 at the same time, because ultimately after 2 years you are eligible to apply for 801. But in a way you may made a combined application at the beginning, so department will straight away grant you 801 along with 820 if it has taken more than 2 years of time. When you apply for 801, you still have to prove that your relationship is continuing. It could be marital, de facto, whatever it is, you have to prove that your relationship is still genuine and continuing. As I said, 2 years after you can apply for 801 visa, and you still have to prove the normal requirements which you had to at the time of 820 application. During these 2 years of time, since you have applied for 801, if in case any situation changes, there is again the standard policy. Department expect that you notify them about your change in the details. That could be your contact details, your passport, your relationship details. In case if you have got a child, notify the department so that child could be included depending on where the child is. Also, in case if there is any familiar violence in place during this time, you notify the department so that they can action your visa application accordingly. So, in terms of family violence, I'll just like to tell you that generally speaking, the requirement to apply for 801 visa is that your relationship is still genuine and continuing. However, there are some provisions where department still can grant you the visa if your relationship is not continuing now. However, it was genuine earlier. So you have to prove to the department that if there's a family violence provision applies, then department can still grant you the visa. You have to prove that family violence occurred after you have applied for the visa, and also that your relationship was at least genuine at that time. Because if you are saying that family violence occurred, but then your relationship is not genuine, department still cannot grant you the visa. So, in the case where your relationship break down because of family violence, department still can grant you 801 visa, irrespective of your relationship. About the future new reforms, department has been saying for some time that they would like to make some changes in partner visa process, the requirements, but it's not happening for some time. We don't know even that will be implemented in future or not, but that has been a hot topic. It's been going on for some time. So there were two changes department was looking into. First of all, the department was saying that they will possibly add English language requirement for partner visa applicants. However, that has been, as I said, has been going for a long time, but then department hasn't made any changes. In case if they add the English language requirement, applicants generally will be required to have functional English, which is 4.5 bands overall in IELTS or equivalent score in other exams which are acceptable by the department. There are some exemptions to functional English requirement, which could be like you have studied in English medium or you're holding passport from certain countries, things like that. But anyway, you don't have to worry about all of that for now because that's not the requirement. In case in future if it applies, you have to meet requirements accordingly. Secondly, department was saying that they may add extra requirement for sponsor first to become approved sponsor for applicant to apply for partner visa application. So for now, the practice is you can apply for partner visa application and sponsorship application from your sponsor side at the same time. So generally speaking, there are two applications in partner visa application. One application is from the applicant side, which proves that okay, I'm meeting the basic requirements for partner visa, and another application from the sponsored side, which has who has to prove that the sponsor is permanent resident citizen, for example, and then sponsor does not have any character issues or police checks for the partner. So that are the main requirements for from sponsorship side. So it happens department found out for some cases that sometimes people apply for partner visa but then their partner does not qualify for the program, and that's where what happens, because the partner visa was taking a long time, and a lot of people, not lot of people but very few people were misusing the program. They were applying for partner visa takes like 1 year 2 years of time, and probably by that time department later on find out that your partner is not even eligible for the program. So the applicants were getting unnecessary time while processing partner visa applications, and that's where department was saying that that can help department in a way that if the sponsor needs, if the sponsor is already approved sponsor, then they understand that the applicant can possibly qualify, and that's where applicant will apply for partner visa. So department was saying that sponsor has to first apply to become approved sponsor. If sponsor meets the requirement and if sponsorship is approved, then the applicant will be able to apply for the visa. However, as I said, this provision is also not applicable for now. We don't know even if it get implemented later on or when that will be implemented. So for now, it's all fine. Okay. Now, if you'd like to apply for 820 visa, as we were saying that you must be onshore. So the first concern is how you will be in Australia, like on what visa you will be in Australia, how you can come to Australia. So there are some options. First option is in the table, as you can see, you first apply for a prospective marriage visa. That's another category of the partner visa, which we haven't discussed, but I'll quickly explain you. So prospective marriage visa subclass 300 is for the people who are outside of Australia and they are engaged, for example, they are in relationship and they are saying that we are planning to get married in Australia. So they need some visa to come to Australia, then only they can get married. So that's where firstly they will apply for a prospective marriage visa. The name itself suggests that you are planning to get married in future. So you'll have to provide some forms, some documents, for example, notice of intended marriage. That is what you file to get married in Australia. So you'll have to submit NOIM form, notice of intended marriage, that we are planning to get married in Australia. Um, One very important criteria for this 300 visa is also that you must have met your partner physically means in person, at least at a time, if at least once. If you haven't met your partner, you cannot qualify for the visa. If you have met your partner virtually through Facebook or any other platforms via Skype or any video conference or whatever it is, you cannot qualify for the visa. You must have met your partner in face to face, in person, at least once, then only you may look at this option. So in this visa, once you get the visa, this visa will be granted for 9 months of time generally. In that 9 months, you come here as an applicant and then you get married in Australia. Then you convert your 300 visa to 820 because now you are married. So you meet the criteria for the partner visa 820. As we were discussing, to apply for 820 visa, you must be either in married relationship or you are in de facto relationship with your partner. So once you are here, you get married with your partner and then you can look at 820. So then the standard process applies. We already discussed that part. Second possible option could be that if your partner comes on a visitor visa over here in Australia, in that case, it could be that you are already married with your partner or you are not married with your partner. If you're already married with your partner, you come on visitor visa, and considering in visitor visa, when you apply for your partner, there could be three possibilities. If they are refusing the visa, you don't have a choice. But to go for the third category, which is like partner visa, provisional visa 309. If visitor visa get refused, because if visitor visa get refused, if your partner cannot come to Australia, you don't have a choice. to apply for 820 visa, because for 820 visa you must be onshore in Australia. So the first possible outcome for visitor visa is if they are refusing it, you don't have a choice but to go for 8309. Second possible option is they are granting the visa but with a condition called no further stay. That means you cannot apply for any visa while in Australia except some of the visas, mainly the skilled visas in Australia. If you have that condition, you have option to request minister to waive that condition. If minister waive that condition, no further stay condition, you can still apply for partner visa. But in case if minister does not waive it, you don't have option to apply for partner visa while in Australia. So you have to make sure that if visitor visa is granted, whether that visa has that condition or not. If it is available, you cannot apply. Also about the waiver, minister generally will waive the condition only in the cases where after coming to Australia your situation changed and that's where you need to stay further in Australia. If you are saying um, that after coming to Australia only I can apply for 820 visa. That's where I could not apply for that 820 visa while I was overseas. That's where could you please remove this condition so I can apply for 820. They will not generally allow you to do that. If you have some specific circumstances after the grant of the visa and you are in Australia and the situation changed, for example, during COVID, the government the applicant was not knowing that okay they could not travel overseas or they could stay here, so in that cases minister waived that condition, then you may look at partner or some other visas, for example. So if there is no further stay you have to get waiver. If there is no visa condition like the no further stay condition, then also you can apply for 820 visa. If you are married you can straight away apply. If you are not married you get married and then apply for partner visa, or if you are proving your de facto relationship you may still qualify, something like that. And then the process is same. In case if you cannot come to Australia for any reason, or you are like I don't want to come to Australia for now, but you are still in genuine relationship with your partner, you are in marital or in de facto relationship with your partner, you can still apply for 309 partner visa from outside of Australia. The process is very similar to 820 visa. So the only difference being 820 can only be applied in Australia, 309 visa can only be applied out from outside of Australia. Process is same. 309 you apply first. From that date of application of 309 you can apply for permanent visa after 2 years of time. So generally speaking, as earlier as we discussed, when you apply for 309 you are making combined application for even 100 visa. So if it takes more than 2 years of time um, to process that application 309, they will straight away grant you that visa. But in case of it is taking less than 2 years, then you have to apply for 100 visa separately in a way. So um, that's the all the partner visa options. Also, I would like to tell you that in some cases you may not have to wait for the first step. I mean you are applying for first step but you are making a combined application. For example, when you are making 820 visa application you are also combining with 801, so you don't ask but internally you are making combined application of 820 and 801. Same way if you are applying for 309 you are making combined application for 309 and 100 visa application. So in some cases even if you haven't waited for 2 years of time, still department can grant you permanent visa which is 820 sorry 801 or 100 visa. In that case you have to prove to the department that you are in a long term relationship. So if you prove to the department that you are in a long term relationship, they can straight away grant you 801 or 100 visa depending on which one you have applied, where you were like in Australia or outside of Australia. Now, the requirement to for long-term relationship is that when you have applied for your first application, which is like 820 or 309 visa application, before that application, you were in relationship with your partner for 3 years or more, then you meet the requirement of long-term relationship. Or at the time of application for the first stage you were in relationship with your partner for 2 years or more, but you have child with the same relationship. So if you prove that, then they can straight away grant you permanent visa. You don't have to wait for that 2 full years to apply for the permanent visa category. So that's very important. But then sometimes if you don't tell department that we are in long term relationship, department may only grant you the first stage. So it's recommended that if you are meeting this long-term relationship, provide a cover letter or make a submission explaining that I'm meeting this criteria. If you can grant me straight away permanent visa. Okay. So the prospective marriage visa, as we have already discussed, it's a provisional visa again, and then the same requirements apply. Your partner must be also a PR citizen or eligible New Zealand citizen, and you must have met in person and provide details or evidence of engagement with your partner. So that's what we already discussed. Um, then after the requirements, as I said, that you must have met in person, and then the requirements anyway we discussed. Once the visa has been granted, 9 months of visa, you get married and then apply for partner visa. Again, we have discussed this already. The provisional partner visa 309 visa, which is leading to permanent partner visa, which is 100 visa category. The applicant must be offshore. That's the main difference. Everything else is pretty much same. 2 years after, you can apply for permanent visa, which is 100 visa category. Same way for offshore people, they still have to meet these four criteria. Sometimes it becomes a bit difficult for people who are outside of Australia to qualify all aspects as such, but then you try to provide whatever documents to prove that you are in a genuine relationship. For example, social awareness. Sometimes it may be possible that you got married and straight away you came here. However, if you have marriage photographs where you can see there are a lot of people invited, they know about your relationship, that is very good proof, and that's where you should provide marriage photographs or any photographs with your friends, family members, for any other events, or for tourism. If you have been, you can provide photographs and documents like that. And then social relationship. Okay, so that was the first aspect. Financial, sometimes again, because you are not living together, so you might not be able to prove that you are paying for things together. But if you have spent money to your partner, sometimes you can provide receipts for that. You bought something for your partner, you are paying for something for your partner who are outside of Australia. You can provide bills, documents like that. So when you are doing something like that, that's where we recommend the clients that if you are doing something like that, better to have your name recorded, make it through official channels. So then you can use that documents to prove to the department that yes, you have been supporting your partner financially or whatever way. Evidence of contact and communication with your partner. So for that, because you are not living together, so household commitments generally does not apply because you are not together for now. So in that case, you prove that you are in constant communication with your partner to prove to prove continuing relationship. You prove that you have been talking to your partner as any other couple will do over the phones, over the video calls, for example. So you provide screenshots or chat history, for example. If you can, if it is English translated, fine. If it is not English translated, you may have to get it English translated if you'd like to use that as an evidence. So you can provide your phone bills, for example, to prove that you have been talking to each other, things like that, which can prove that you are in constant touch with your partner. So in this case, for example, you are not living together, but your separation is also not a permanent separation. You are saying we are just living temporarily, separately. Once we get the visa, we will anyway live together. So you still meet the criteria. And then the mutual commitment, which is standard commitments, that what are your future plans, how you will commit each other, what you have planned in future, what you're going to do, things like that. um, and then the standard of the requirements apply, which is health and character requirements. On top of this, I would also like to let you know that for partner visa there are some limitations in terms that your partner can only sponsor you if your partner has not sponsored anyone in past within last 5 years. So there are standard limitations where if a permanent resident or Australian citizen or eligible New Zealand citizen, if they have sponsored a partner in past, they can sponsor one more partner. So maximum a permanent resident or citizen person can sponsor will be two people. Um, there is a possibility that they can sponsor more people, but that will be in very limited situations where there are some serious circumstances they have. Only in that cases they would be able to sponsor more than two people, or otherwise standard rule is they cannot sponsor more than two people. That means if they have sponsored one person in past, they can sponsor possibly one more sponsor if the relationship break down, they are not together, for example, and now you are in relationship with that person, you may still apply, but not more than two times. The same rule applies where if you got permanent residency through partner visa, because someone else sponsored you earlier, you cannot get into some other relationship and sponsor another partner for next 5 years of time, unless there are specific circumstances as such. But then 5 years is the ban period, or the period in which you cannot sponsor another person. So if you have got partner visa by yourself, 5 years you have to wait until you apply for your partner's application. Now, very importantly, the 5 years ban period starts from the date you applied for your partner visa application, or in the case where your partner sponsored other person in past, from the date when they applied for the first partner visa application, which could be 309 or 820 application. So 5 years from that date applies. So they cannot sponsor any other person for next 5 years of time. So two things, they cannot sponsor more than two people, first requirement, and secondly, if they haven't sponsored two people in past, they just sponsored one person in past, still second person if they would like to sponsor, still there is a five years of waiting period apply. So two requirements, 5 years gap in between and not more than two people. So if you waited for another 5 years, you cannot sponsor third person. So two limits, two-person in total and 5 years of gap in a way. So that's what the standard limitations. There are some other limitations as well, but if you have any specific queries, you can contact us and we will be happy to help you with your particular queries, and help you with the partner visa process. So that's it for the session. I'll quickly go through any questions we have. Um, but as we stated earlier, we have some giveaways. So we have really attractive giveaways for you. Give a shout out about conclave session in the link provided in the chat box. It's already been posted there, by tagging Aussizz Group and Aussizz Conclave 2022 to win some exciting offers. Offers include free permanent residency consultation, free TR consultation, and some PT, IELTS coaching, a NATI coaching, CCL coaching. So if you have your friends, family members interested in getting some coaching, you can also forward them about our services, the links, and we'll be happy to help them as well. Okay, I'll just quickly go through the questions if I have any. Also, just to let you know, we have shared some links for the ongoing session or future sessions. We are doing sessions until I think 6. So if you would like to join any of that session, or you have any friends, family members who are interested, because probably it's applies to them, share the links to them. That will be highly appreciated. Um, and as we discussed, we are providing PT, IELTS, CCL coaching. We are also providing professional year program enrollments for engineering, IT, accounting students. So if you, your friends have any query as such, they can contact us. Okay, about the queries, I have Ramesh asking, we are recently married and my wife left her work as a company isn't giving 2 months leave for the marriage. So I didn't understand the question, but then if you are getting married and if you are a permanent resident, you can apply for a partner visa for your partner. So you have option of applying for 309 visa directly once you get married, or you may apply for a visitor visa for your partner if she can get the visitor visa without any condition as such, no further stay condition. That's what we were talking about. So then she can come here and we can apply for partner visa for your partner. So we can help you with both visitor visa and partner visa. Or if you are like, I don't want to bring my partner for some time because of any reason, for example, your partner is studying there or would like to gain some experience there, then you may look at applying for 309 visa application, and then once it is granted, your partner can come here. One more difference for this 309 and 820 application is that 309 or 100 visa application generally, because that's offshore application, get processed in high commission, Australian High Commission in that particular country where Australian High Commission office is located. And if you apply for 820, 801 application, then application get processed generally in Australia. So that's why generally there are more applications getting processed in Australia because people from any nationality can apply in Australia, and that's where more application will be there. The processing time could be a bit higher compared to 309 or 100 application, but you can say very similar processing time applies now. Urvish is asking, is this relative who is not permanent resident or Australian citizen, for example, a student who wants his overseas partner to welcome in Australia, if the 820 partner, okay, is this relevant who is not PR? Okay, so the partner visa we are talking about is not relevant for people who are holding temporary visas. So the same thing, the difference being, if you are holding permanent visa, that could be any permanent visa. It could be skilled permanent visa 189, 190, 491, business visa, global talent visa, or any other permanent visa, doesn't matter. You are applying for your partner, but then you are a permanent resident or Australian citizen, then whatever things we have talked today applies to you. If you are holding a temporary visa, you would like to call your partner, or your partner is on temporary visa and you would like to apply for that visas, then it's, if it is, for example, a student visa, you will apply for a student dependent visa. However, the visa number will be the same, 500 visa. If you would like to apply for 485 visa because your partner is holding 485, which is like TR, temporary graduate visa, then you will be applying for the same TR visa, 485 dependent visa. So for any temporary visa, the same visa subclass as a dependent visa you will apply for, but for any permanent residents, once they become permanent resident, they will have to go for the partner visa. Um, Haruka is asking, if the 820 partner visa application takes a year to process, the partner would be on a bridging visa, as you mentioned. Will they get Medicare during that time, or do they have to have OVHC? So as I said, once you apply for 820 visa, you get a bridging visa A, and because you have made a permanent application, because you are making a combined application 820, 801, you are eligible to apply for Medicare. So you don't have to wait for the visa grant. As soon as you apply, you can take the acknowledgement of that visa application lodgement through Medicare, and or you can apply online, and they will be sending you the card to your address. One more thing about the charges for this application. Generally, department increase the charges for the partner visa from 1st of July onwards, but currently the visa application for partner visa is, I think, somewhere around $8,000. Last financial year it was 7,850. So that's what you make the payment. It's combined application. That means when you apply for 820, at that time you are paying for even 801. So whatever payment you have made, $8,000 approx, is combined fee for 820 and 801. So later on, if you have to apply for 801, you don't have to pay to the department. And other charges includes medical examination, visa processing, medical examination and character, that is police checks. If in case, if you are from certain countries, you may have to do biometrics, you may have to do some vaccination like polio vaccination, things like that. Um, Saurabh is asking, can we get links for the other sessions? Yes, that's what we have already posted there in the group. Um, okay, so that's pretty much it. I have tried to cover whatever I can for this session. If you have any query, then you can contact us through any channels. You can just search in Google for Aussizz Group, or I have mentioned the contact details where I'm available. So you can contact us on that number, and we can provide you a free consultation because you are attending the session, and we can provide you with a detailed consultation and how to proceed with the processing. We also recommend you to recommend your friends, family members um, to take, or if they have any queries, we request you to recommend them to take consultation, and we would love to help them as well. That's it for the day, for the session. Thank you and have a good evening.